Welcome to the Supreme Court of the United Kingdom, where we are hearing the appeal in the case of Gourlay and the Parole Board. I'm hearing this case with Lord Hodge, Lord Lloyd Jones, Lady Arden, and Lord Leggett. Details of the case can be found on our website by going to current cases. The issue put very shortly is whether an order for costs can appropriately be made against the Parole Board, or whether, on the footing that it is a court or tribunal, an order for costs would be inappropriate. We're currently hearing submissions on behalf of the board presented by their leading counsel, Mr. Ben Collins, Queen's Counsel, and so I'll invite Mr. Collins now to resume his submissions.
My lords, my lady, yesterday I dealt with the status of the board, and today I will go on to deal with the question of costs, and in particular Davis. Before I do so, just two short matters to tidy up from yesterday. First of all, yesterday a query was raised by my lady, Arden, about the numbers of claims for judicial review of the board's decisions and the costs of those claims. And a note has been provided to the court, and the court will see we've been able to obtain figures for the numbers of claims, but it hasn't been possible to identify amounts of costs. What the board was able to do was give me one or two examples of costs in recent cases, but we were rather hesitant about providing those. It seemed to us we couldn't confirm whether they were fairly representative, and we didn't want to put information before the court which might risk being inaccurate or misleading. So far as the number of claims is concerned, they're there to give you some broad context, but we really caution on relying on them for anything more than that. And in particular, we suggest it would be risky to draw conclusions about trends from the figures. We'd need much more information to understand, for example, why numbers go up and down over time. One can think of immediate examples. One can get something of a rush of claims following a significant appellate decision like Brooke or Osborne. And we also have questions about claims which are brought as JARs, where the board's view is they should really be brought in the county court. And in fact, in the litigation strategy, that's flagged up. So we provide the figures for what they're worth. If questions arise from them, of course, I'll do my best to deal with them. We don't suggest that they can be relied on for much more than broad context.
Well, I certainly remember from the time when we were dealing with cases like Faulkner and Sternham that there was a very large volume of cases concerning IPP prisoners.
Yes.
And I suspect that those may largely have worked their way through the system by now.
My lord, I suspect that's right. There was undoubtedly a rush of claims to do with backlog in particular,
Yes,
exactly. The large numbers of prisoners who required hearings as a result of the introduction of those sentences.
Yes.
Well, that's the reason why I'm hesitant to try to delve too far into these, because it seems to me that perfectly possible there are all sorts of different reasons which may come into play to explain why the figures as they are. We present them so that you can see what they are. We don't seek to comment on why they are.
Yes, thank you very much.
Thank you.
One other short matter, just to clarify before I deal with the question of costs, and it's a matter which arose from a learned friend's submissions yesterday when you were told that the Secretary of State didn't participate in terms of making submissions to the board in this case. And we thought it right to draw to the court's attention that the decision letter makes clear that a number of the Secretary of State's officials appeared before the panel in the form of a prison psychologist, an offender manager, and an offender supervisor. And it's apparent that not only did they give factual evidence, but they also expressed opinions about what the board should recommend. And the board records that the view of the witnesses was this is from page 187, you cannot reduce your risk factors without attending an SOTP course. So to that extent, the officials of the Secretary of State did express a view as to the appropriateness of a move to open conditions. We just wanted to clarify that before I move on to the question of costs.
The offender manager would be from NOMS, was he?
Yes.
And the prison psychologist and the offender supervisor, would they be from the prison service? I
think that's right, but what I'll do is I'll ask my Gina to double check on that and send me a message to confirm it.
Yes, thank you.
Well, if it's not right, I'll correct that. If I don't come back to the topic, I think my lord can assume that it is right.
Yeah.
Can I turn then to the question of costs? And our starting point, perhaps inevitably, is the proposition that an appeal court will only interfere with the exercise of the discretion on costs where the judge below has erred in his approach or has exceeded the wide ambit of the discretion such that his decision is wrong. Those are words taken from the Court of Appeal in Fakiri, but the proposition is, I suspect, a pretty obvious one. Can I start, please, with the statutory framework and Rule 44.2, which is in the Supplementary Authorities bundle, tab 85, page 144. And it's not in doubt that, pursuant to Rule 44.2.1, the court has a discretion as to whether costs are payable by one party to another. And we know that Mr. Justice King exercised his discretion not to make an order. And so the questions raised by this part of the appeal are whether he was entitled to take into account the status of the board when exercising that discretion. And I addressed you yesterday on what he was entitled to find about what the status of the board was. But if so, if he was entitled to take that into account, whether the decision to make no order was within the wide ambit of his discretion. And strictly speaking, because he declined to make an order, CPR 44.22 in fact never arose, which indicates, and that's the rule which sets out the general rule that the unsuccessful party will be ordered to pay the costs of the successful party, but the court may make a different order. Now, we don't go so far as to say that neither of those factors are matters which he should have taken into account, and we accept that they will offer some assistance as to the exercise of the discretion under 44.2.1. But we make what is perhaps the obvious point that a neutral party is not the same as an unsuccessful party. And if the general rule might be said to apply to these circumstances, we're wrong about the proposition that a neutral party is not the same as an unsuccessful party. Nevertheless, one faces the same question as I've already identified. Was the judge entitled to take into account the board's status? And was his ultimate conclusion within the wide ambit of his discretion? What is, we would suggest beyond doubt, is that the judgment of the Court of Appeal in Davis establishes that the very long and consistent practice of domestic courts has been that it is appropriate to take into account the status of a defendant when it is a court or tribunal, and that it's appropriate to make no order where a court or tribunal takes a neutral stance when one of its judicial decisions is the subject of a claim for judicial review. And of course, what this court's asked to consider is whether Davis remains good law. And in order to decide that, it's necessary to consider what the role of a court or tribunal is in litigation of this sort. We respectfully agree with the appellant that it's not enough to show what the practice has been. It's also necessary to consider why it should be the practice, whether the practice is right as a matter of law. given that we're agreed about that, we say it's nothing to the point from a learned friend to say, as he did yesterday, that our explanation for the approach goes beyond what is contained in Davis.
Could I just come back to your last statement for a moment and just ask a question about what the function of the appeal court is? There is a distinction, is there not, between asking whether the decision in Davis was justified by reference to the authorities which preceded it, and whether it represents the law, and whether, as it were, that is the legal principle which applies in this situation. But when it comes, could I suggest as a distinction, and just invite your reaction, is there a distinction between that and asking whether the ultimate rule is fair on a much broader basis than simply asking whether it's a rule established by the authorities and whether it's a rule which represents the common law? Is there a point at which the overall inquiry into fairness, such as the resources of the relative parties and so on, goes further than the normal judicial process?
I think, my lady, the way that we would invite the court to look at it is this, which is to say that this court can look at whether what the judge at first instance took into account was properly taken into account. So whether the matters to which he had regard were relevant to the exercise of his discretion. The starting point for that will be the authorities and the appellate authorities which give guidance as to the matters which govern the exercise of the discretion. And Davis, we say, would have been the starting point for that. But it is possible to go a little further than the authorities because there are questions of principle, and what the appellant says in this case is that circumstances have changed since Davis, such that the conclusion of the court in that case no longer applies. Now, of course, we take a different view so far as that submission is concerned. We perhaps don't go so far as to say it's a broad question of fairness, but we do say it's a question of lawfulness within the common law, and that questions of fairness may inform that, if I can put it that way. So one of the issues which I'll need to come on to deal with is whether the rule offends against the principles of the common law which require parties to have appropriate access to justice. Now, there are elements of fairness within that analysis, but it's not a broad brush question of whether a policy is fair and reasonable or not. It's a more focused question we would submit, which addresses the question whether the matters which the judge took into account properly reflected the law. I don't know if that answers his question.
Yes, indeed. But does there come a point, just to go down a branch of the answer, does there come a point when the judicial decision should leave it for practice directions? There's a statutory power there is now a statutory power which reflects the court's inherent power to make practice directions. And that particular codification took place because it was desired to place limits on the courts as to who could give the practice direction, not as to the content. And that occurred in 1997. So I was just asking the question, is there a point at which adjudication, as it were, has to fall short of practice directions, or are they overlapping? And if so, in what circumstances?
Well, I'm sure there does come a point where one drifts from questions of law to questions of practice. One of the matters which my learned friend and I are going to address this court on by way of supplemental written submissions may be which side of that line this case falls on. Our preliminary view, if I can put it that way, is that the issues in this case are issues of law rather than issues of practice, and they are suitable for determination by by the court. Certainly the issues which I intend to address the court on this morning are matters which go to questions of how the common law informed, likely, if I can put it that way, perhaps by the convention, have to be applied by a judge in the position that Justice King was in this case. But I don't go so far as to set out what we say would be, for example, a desirable regime for the management of costs in judicial review claims relating to courts more broadly than the exercise of the discretion in the context of this case.
Thank you.
So, my lords, my lady, we submit, and the court may have seen this from our case, that there are three particular features of a court or tribunal which inform the approach that should be taken to the exercise of the costs discretion in this context. The first of those is impartiality, and the principle that a court should remain neutral and not enter the fray to oppose or support one party or the other. Secondly, independence, it being essential that a court acts with freedom from the influence of the executive, and of course this particular context, the board, in the context of the board, we note that the executive is a party to all of its adjudications, and so the need for independence to that extent is also a feature of the need for impartiality. And the court must not be subject to pressure from either party to seek to change a decision once it's been properly made. And the third feature is to do with reasons, and it's that a court's reasoning should be set out in its decisions rather than being amplified, explained, or justified on appeal or review. And sitting behind those three features, perhaps, is a further matter which we say should be borne in mind as a means of ensuring the maintenance of independence and impartiality, and that's the principle of judicial immunity. And I will expand upon those features in the course of my submissions. I set them out now by way of introduction because it may be helpful to have them in mind when considering the authorities. Now, in our case, we have identified a range of courts and tribunals who appear or have appeared as defendants to claims for judicial review. And of course, we invite the court to note that in each case, the role of the court there is not to contest the proceedings, but rather to remain neutral. I don't propose to go through them all. Can I ask the court to begin by looking at another judgment of Lord Justice Brooke, and that's in the case of Stokes and Gwent Magistrates Court. Authorities Bundle, tab 59, page 1620. And it was an application for judicial review of a decision of justices committing a defendant to prison. Can we ask you, please, to look at page 1624? Because we see here perhaps the origin of the form of the boxes to be ticked on the claim form. So can I ask the court, please, to read paragraphs 22 and 23? Now, I can't say with certainty that this judgment is what led to the present form of the claim form, which has the box which was ticked in the present case, which is that the defendant is a court or tribunal and doesn't propose to participate in the proceedings. But it may well be that these observations of Lord Justice Brooke played a role in that. And one sees that the reason why a court is given that option is what Lord Justice Brooke says at paragraph 24, which is, in the context of magistrates at least, that practice was for magistrates to put in affidavits rather than appearing in person. The reason for that practice being an issue of principle, the last sentence of paragraph 24, that the role of justices is not and should not be an adversarial role. And we suggest, of course, that that's true of the board as it is of many of those tribunals that we've identified in our case. The list of examples that we have offered is set out in our case, and I'll just draw the court's attention to it rather than going through it. It's page 118 of the core bundle. It's paragraph 63, where we first of all identify the box to be ticked where the defendant is a court or tribunal, and then we identify those various bodies with examples where they have been noted to have taken a neutral role. So that's the Crown Court, the Upper Tribunal, the First Tier Tribunal, coroners, of course, but also the Central Arbitration Committee, disciplinary tribunals. We've cited the Solicitors' Disciplinary Tribunal there, and the Ombudsman. And without asking the court to look it up, it's contained within those decisions about the Ombudsman is also the proposition that an arbitrator may be treated in the same way.
This is only a list of the people who look like courts as we generally recognise them, but the list is actually much wider than this, isn't it? There are a whole lot of other persons.
They're no more than examples, we certainly don't suggest it's an exhaustive list. But it's not difficult to find examples. Perhaps is one of the reasons to identify them, and some of them are commonly found, just as the board is. The example of coroners is perhaps a good one. Commonly found appearing in judicial reviews and remaining neutral, and we say that that is generally established to be an appropriate course. And we say that not only in this jurisdiction, but we say that's generally an approach which is approved internationally. The court may have seen that we have referred to the United Nations document, the Bangalore Principles, and in the authorities bundle behind tab 80, starts at page 2065, is that UN document which includes the principles and some commentary on them. The introduction to the document identifies the principles as increasingly being recognised as principles which all judiciaries and legal systems can accept. And there's just one passage from it that he asked to draw your attention to. Starts at page 2094. Principle 2.4, this is about commentary. A judge shall not knowingly, while a proceeding is before or could come before the judge, make any comment that might reasonably be affected to affect the outcome of such proceeding or impair the manifest fairness of the process, nor shall the judge make any comment in public or otherwise that might affect the fair trial of any person or issue. And permissible statements are discussed lower down on the same page at paragraph 72. Makes it clear that the prohibition does not extend to public statements made in the course of the judge's official duties, to the explanation of court procedures, or to a scholarly presentation made for the purposes of legal education, nor does it prohibit a judge from commenting on proceedings in which the judge is a litigant in personal capacity. In judicial review proceedings where the judge is a litigant in an official capacity, however, the judge should not comment beyond the record. And that's part of what we say is the principle that the reasons for a court should stand for themselves, but it also goes to the issue of the court remaining impartial and not weighing into proceedings on one side or the other. There's a short passage which may also assist further down the page, paragraph 74, in the context of media criticism, only partly relevant because we're not talking about media discussions here. But halfway through the paragraph is a sentence which says, if the media or interested members of the public criticise a decision, the judge should refrain from answering such criticism by writing to the press or making incidental comments about such criticism when sitting on the bench. And the following passage we say is relevant. A judge should speak only through his or her reasons for judgments in dealing with cases being decided. It is generally inappropriate for a judge to defend judicial reasons publicly. Now, on the one hand, that is set in a slightly different context, and it is intended to deal with media criticism rather than criticism in the context of a claim for judicial review. But the same principle informs it, which is that a court's decisions should be explained in themselves rather than being added to subsequently. And that's consistent, we say, with domestic expectations of judicial decisions. That is to say that they are sufficient to allow the parties, and if necessary, any appeal court, to understand the principles on which the judge has acted and any reasons that have led him to the decision. And we take that from the well-established Court of Appeal decision in English. I can take the court to very briefly. Authorities Bundle, tab 24, the relevant passage at page 810, 810. Passage begins at paragraph 15 under the heading, the requirement to give reasons under common law, to D. It begins with the general recognition in the common law jurisdictions it's desirable for judges to give reasons for their decisions. And a number of justifications for that are explained. Just by E, it's said that while a constant refrain is that reasons must be given in order to render practicable the exercise of rights of appeal, a number of other justifications have been advanced for the requirement to give reasons. These include the requirement that justice must not only be done, but be seen to be done. And that's a requirement which we say informs a number of aspects of the present case. But at its shortest, perhaps, paragraph 16 of this judgment, the court says we would put the matter at its simplest by saying that justice will not be done if it's not apparent to the parties why one has won and the other has lost. And then at paragraph 17, there is an explanation of the adequacy of reasons and a quote from Eagle Trust, a well-known quote, which says, a judge should give his reasons in sufficient detail to show the Court of Appeal the principles on which he's acted and the reasons that have led him to his decision. That was said to be in the context of an application to strike out, but at paragraph 18, the court said, in our judgment, these observations apply to judgments of all descriptions. So, put shortly, we say decisions of a court should stand on the reasons given by the court to the parties, and judicial decision makers should not enter the fray to amplify reasons in support of one party, because once one gets to a judicial review or an appeal, to amplify the reasons one way or another lends support, of course, to the party in whose favour the court has found. Where they do that, where the judicial decision maker does that, then of course they can expect to be liable for costs. And Touche is perhaps a powerful example of that. And the Touche case is Authorities Bundle tab 4, starts at page 358, but the relevant passage is 373. And we find at C a description of what happened in that case. And the Touche case was notable to this extent, that the coroner took an active role and argued with vigour for one course of action. And of course, the coroner is in a slightly different position than some of the tribunals to which the authorities refer, because an inquest is not a lis inter partes. There are interested persons at an inquest, but there are not parties. And it may be that the interested persons have different perspectives and may ask a coroner to reach different conclusions about matters within his or her jurisdiction, but they're not parties. Touche was a case arising from allegations of clinical negligence. And we know not what the position, for example, of the hospital would have been before the trust, whether this was a case about whether an inquest should be held at all. So the dispute was in reality between the coroner and the claimant. We know not whether the hospital was in favour or against the holding of an inquest. But the Court of Appeal in Touche asked itself what role the coroner was playing. It's just above C. What role is this coroner playing? True, the point at issue is one of considerable importance, yet the point having been resolved against him at first instance, he then appealed. An amicus cannot appeal. Having appealed, as Mr. Burnett recognises, the coroner is to be treated like any other appellant. If he wins, he recovers his costs. If he loses, he pays the respondent's costs. Why then should the position be different below? Indeed, had the coroner won below, he would certainly have asked for and no doubt been awarded his costs. Now, that's a quite different position than we're looking at in this case. The board doesn't suggest that it should recover costs in cases where, as here, it remains neutral. At paragraph 55, the court recognised that if coroners who appear and lose are regularly to be condemned in costs, they may be more reluctant to be represented at the hearing, so that the court would be deprived of their assistance. And he expresses the view that that would be a pity. But he says this: it would always be open to the court to ask for an amicus, and at least then the applicant's position as to costs would be fair. He would simply have to bear his own costs irrespective of the outcome. So in those circumstances, I'll pause there. My Lord Leggett has a question, I think.
I just wanted to ask whether it's in principle appropriate that a judicial officer, say a coroner, can have it both ways, as it were, and choose whether they want to argue to uphold their position. I mean, if the principle is that in order to be impartial, you must let your reasons speak for themselves and not amplify them or defend them on an appeal or challenge, what's the basis on which a coroner or the parole board can decide that in some cases we'd nevertheless like to do that? Because if you're allocating yourself that right, why then should you have a corresponding immunity when you don't choose to exercise it?
Well, that will be a question for the court hearing the judicial review or the appeal in a given case, because one of the things that the court will have to decide was whether the court or tribunal has acted reasonably. And of course, it may be that a court concludes that it wasn't appropriate for the coroner or the board or whoever it may be to participate actively, because their reasons ought to stand for themselves. And if the court concludes that it's not reasonable and not appropriate in the circumstances for the coroner or the board or whoever it may be to have participated, that will, of course, be a factor in any conclusions they reach about costs. So we wouldn't say it's a case of the judicial decision maker having it both ways, if I can put it that way. if they choose to enter the fray, they do so at risk of criticism. The conclusion reached in this case was that the coroner was entitled to act as he did. There may be other cases where it's felt that it's inappropriate, and one can see that in some of the cases considered in Davis. And I'm going to go on to look at there are some jurisdictions where it's felt, broadly speaking, inappropriate for a court or tribunal ever to speak to its reasons. Our jurisdiction perhaps has a little more flexibility than that and recognises that there may be circumstances where the court or tribunal may participate. There is, in some cases, perhaps a fine line to be drawn between a tribunal which participates to assist the court, for example, with questions as to jurisdiction or process, and one which seeks actively to defend its own reasons. One of the things the appellant says is that makes the rule in Davis particularly unsuitable, because how is one to tell the difference? And indeed, Lord Justice Simon Brown in Touche was rather concerned by the proposition that how does one decide which role the coroner is playing? But the answer to that is that the judge determining costs has a discretion, and there's an evaluation to be made by the judge as to the conduct of the tribunal. If for whatever reason the judge concludes that the tribunal has overstepped the bounds of neutrality, or indeed has for some other reason acted unreasonably or inappropriately, well, that will be a factor which will weigh in the discretion on costs. Because decisions on costs are discretionary, it isn't possible in any circumstances to lay down a hard and fast rule. We would suggest it's not a case where one can have a blanket ban, if I can put it that way, on courts participating in any particular manner. It's a matter for the discretion of the court to assess how the judicial decision maker has acted. So just looking at where that led the Court of Appeal in Touche at paragraph 55, it led to a conclusion that in cases where the coroner didn't participate, that an amicus was available to the court to provide assistance as to the legal issues which the coroner otherwise might have assisted the court with. In those circumstances, it would be fair for the claimant to have to bear his own costs. So Touche is not authority for the proposition that a claimant should never have to bear their own costs in a judicial review, or that a court's remaining neutral such that there is no party from whom the claimant can seek their costs is in some way unfair or inconsistent with the requirements of access to justice. And we say that the principles that we have identified, that's independence, impartiality, and the duty to give reasons, provide a legal explanation why the practice identified by Lord Justice Brooke in Davis was one which could be derived from a century of authorities. And we say that also explains why this case, Gourlay, is just one of 3 recent decisions of the Court of Appeal upholding Davis. The others, of course, as you've heard, being Fakiri and Gourlay. Can I ask the court to look first at Fakiri? It's Authorities Bundle tab 2. It starts at page 346. The relevant passage is at 356. This is in a passage from the judgment of Lord Justice Longmore, who, of course, sat on the Court of Appeal in Davis. and in a passage where he considers M and Croydon, which is a case concerning cost in judicial reviews, which I'll come to in due course. But paragraph 30, Lord Hodge has a question.
Here at page 356.
356, my lord. Can I ask the court to look at paragraph 36, please?
Is this the Fakir case?
I'm sorry, my lord. I didn't catch that.
Well, on 356, I have the Gourlay case, but I may be wrong.
I think you said Fakir.
I'm so sorry. It's my 336. I think
336. Thank you.
356 is where I was going to go next. And I've confused myself. I'm sorry about that. It's paragraph 20 on 336. Starting perhaps with paragraph 19, the general rule from CPR 44.2 applies to a public law claim as much to a claim in any other part of the justice system. And then paragraph 20, and this is Lord Justice Hickinbottom, the courts have long recognised the need for a different approach where the decision challenges that of an inferior court or tribunal over which the High Court has a supervisory jurisdiction, and the challenge comes by way of judicial review only because of the absence of a statutory right of appeal. The court or tribunal is usually required to provide reasons as part of its decision, and in such cases, as in the case of an appeal, it does not usually seek to justify its own decision over and above those reasons, and therefore does not usually seek to play any active part in the claim. So that's a very recent confirmation of the reasons part of the justification for Davis. And can I then look at page 356? Apologies for having gone there earlier. Paragraph 36, again, dealing with M. This is Lord Justice Longmore. There are good reasons why the M case makes no mention of claims for costs against tribunals. Any consideration of the topic would have to take into account not only the stream of authority of which the Davis case is only the culmination, but also the novelty of the idea that any tribunal should, as a matter of normal course, be liable for paying the costs of setting aside one of its orders, if the party against whom proceedings are brought does not seek to defend the tribunal's order. The proposition for which Mr. Drabble contends might apply to appeals just as much as to judicial review, at any rate if the tribunal were joined as a party to the appeal. And he observes that the present case is only brought by way of judicial review rather than appeal because it's an excluded decision under the Tribunals, Courts and Enforcement Act and the order made under it. It would be a serious step to say that in any undefended appeal or judicial review, the tribunal would be at risk as to costs, and any such conclusion cannot be implied into the decision in M. And we say that that's right. There's no difference of principle between an appeal and a judicial review for these purposes. Decisions of some courts and tribunals can be challenged on appeal, others only by judicial review. And that's true even within the modern tribunal system, where some decisions of first-tier tribunals are susceptible to appeal, but others only to judicial review. And there's no reason of principle, we say, to treat them differently by reason of what is often an accident of statutory development. We say they should be treated in the same way for the same reasons that we've identified of independence, impartiality, and the duty to give reasons. Now, Lord Justice Longmore, in this case, goes on to identify further the difficulty that awards of cost would represent an inroad into the principle of judicial immunity. And that's the next paragraph, paragraph 37, where he says that such a step would be a substantial inroad into the normal rule of judicial immunity. Counsel for the FTT made it clear he didn't submit there was an absolute bar to holding the FTT liable in costs. and reference there to truly flagrant improper behaviour. But he did submit with some force that there should be no such general extension of the kind contemplated by Mr. Drabbl's submission, since it would be inconsistent with the normal principle of judicial immunity set out in Syros and Moore. And he identifies a further problem, that whereas there are express statutory provisions whereby coroners are indemnified in respect of any personal liability for costs, there was no similar provision indemnifying members of the FTT, and no indication in the legislation that the FTT has a separate legal personality. I'll come back to that question in a moment, if I may. It's a point upon which I know the appellant places some reliance. Before I do that, can I look at how this is dealt with in Vakiri? I'm sorry to hop between the two cases, but it's in fact the only way to deal with it in a logical fashion. So back to Vakiri, please, 338, where Lord Justice Hickinbottom deals with Lord Justice Longmore's judgment in Gourlay v Sieno. Paragraph 25 sets out his understanding, and we say it's a proper understanding of what Lord Justice Longmore's judgment means, and confirms the reasoning. And then at 26, Gourlay v Sieno subsequently confirmed, indeed reinforced the principle in Davis, where an inferior court or tribunal was a formal defendant, no order for costs would be made unless it had acted improperly or taken a positive non-neutral stance in the litigation. It also better identified the underlying general rationale, namely judicial immunity. And we say that approach is right because a judicial decision maker must be able to do his or her duty with complete independence, and that independence would be undermined if the judicial decision maker had an interest in the outcome of an appeal or review in terms of a liability for costs. And we say that's true whether or not there's an organisation which will indemnify the decision maker. In the modern court and tribunal system, that's true of the vast majority of judicial decision makers. But we say this is a question not of pragmatism, but of principle. It's not a pragmatic question of the cost to the pocket of the individual, but it's a principle which arises from the importance of maintaining both independence and the appearance of independence. Now, several times yesterday, my learned friend submitted that judicial immunity is only relevant to an individual decision maker and not to a decision-making body. And we suggest that isn't right. The submission was made in reliance on a case provided, one of the cases provided on Tuesday, I think. It appears in the supplementary bundle. It's Mazar and the Lord Chancellor, tab 85. It starts at page 290. And we say it's not authority for the proposition for which the appellant relies on it. Mazar was a claim under Section 7 of the Human Rights Act. It sought a declaration that an order of Mr. Justice Mostyn amounted to a violation of the claimant's Article 5 rights. But the declaration was sought against the Lord Chancellor in circumstances where Section 9 of the Human Rights Act makes specific provision for how Section 7 claims needed to be brought in respect of judicial acts. So there was no claim against the judge. And this is a particular kind of claim created by Section 9 of the Act. I can ask the court to turn to page 308, paragraph 86. President of the Queen's Bench Division set out how a claim under Section 7 works. I can perhaps leave the court to read that to yourselves. one can see that present purpose, a slightly unusual sort of action, which makes statutory provision for a claim for damages to be brought in respect of judicial decisions in specific defined circumstances. We go up just a little way to paragraph 84. We can see that before the Court of Appeal, it was common ground that the principle of judicial immunity applies not only to an action for damages against the judge personally, but also to an action for a declaration. But the submission for the claimant with which the court agreed was that the principle of judicial immunity had nothing to do with the present case, because no one was trying to bring a claim against Mr. Justice Mostyn for anything. And that's because of the nature of the claim. The claim was brought under the Act and had to comply with the requirements for bringing a claim under the Act. It's nothing to do with, with the greatest respect, the question whether judicial immunity applies to a judicial making body such as the board. It's not authority for the proposition that judicial immunity applies to individual decision makers if they are performing their function of decision making within a body which is not constituted as a body corporate, such as the first tier tribunal, but it does apply to those decision makers if they perform their function within a body which is so constituted, such as the board. It would, we respectfully suggest, make no sense for the principle to be applied in that way, because if so, it would fail to perform its function of allowing the judge to do the job that they're required to do. So we say that it's in reality an obvious proposition when one considers the rationale for the principle of judicial immunity. It's a means by which independence and impartiality are maintained. The decision maker must be able to do his or her duty with complete independence. That independence is undermined if the decision maker has an interest in the outcome. And that proposition is true, indemnity or no indemnity. The principle is important in this context, not because of financial risk to individuals, but because of the issue of principle that we've already identified. And having given that decision, as we've identified, the decision maker should not ordinarily then be weighing in by argument to support one party of another, all the more so if at fear of a costs penalty. And one can see perhaps that from the perspective of the appearance of independence, a member of the board might be thought to be concerned by to protect the board's interests as well as their own personal interests. So from that perspective, immunity is also important. And particularly so where one of the parties is the executive, as in parole board proceedings. And to do otherwise, we say, risk compromising the decision maker's independence and impartiality. And so the immunity is a means of safeguarding that. And so we say that the principle identified in Davis and upheld by the Court of Appeal in this case, in Gourlay and in Fakiri, accords with both long-standing authority and with principles which have been identified as some of the cornerstones of our legal system. And we say, of course, that the repeated affirmation of this approach by the Court of Appeal, and in particular, those three recent affirmations in the context of the modern tribunal system, is something to which this court should pay close attention when considering its conclusion. Now, before I turn to the question of legal aid and whether that changes the analysis, we have offered the court two perspectives from other jurisdictions, that is to say, Canada and Ireland. And we suggest they are consistent, at least, with our proposition that there is some element of broad international consensus about some of the matters that we've identified. I'll try and deal with them as briefly as I can, because plainly they're not central to the court's approach, but they may be of some assistance. The first of them is a case from Canada called Ontario Energy Board. It's behind tab 74 in the authorities bundle. It starts at page 1953. And it arises from factual circumstances set out on the following page about the regulation of utility rates, where there's a board which approves of costs and equally may disallow them. And this case arose in the context of that. My Lord Lloyd Jones has a question.
953 in which bundle?
It's authorities bundle tab 74.
We don't have the hard copies, I'm afraid, so we only have the electronic copies. Are we in
It's
the
page one? The authorities bundle page 1953.
No, I'm told there's no 1953.
We do have it at 1953 in the main bundle.
Got it now. Thank you very much.
My Lord, I'm very grateful. The relevant sections are at 177. There's a section headed Analysis and section A, the appropriate role of the board in this appeal. And the discussion at paragraph 41 of an administrative decision maker's participation in the appeal or review of its own decisions. And it said that that participation may give rise to concerns over tribunal impartiality. I'm sorry, my Lord, you've not been unmuted yet, so I can't hear you. My Lord, I'm sorry, you were on mute throughout that. I haven't heard what your question is.
Sorry, I'm having difficulty catching up. What's important I follow. 1977, paragraph.
41.
Thank you.
So, my Lord, there's a discussion about an administrative decision maker's participation in the appeal or review of its own decisions may give rise to concerns over tribunal impartiality. Judge noted that active and even aggressive participation can have no other effect than discredit the impartiality of an administrative tribunal, either in the case the matter is referred back to it or in future proceedings involving similar interests. And then over the page, he further observed tribunals already receive an opportunity to make their views clear in their original decision. It abuses one's notion of propriety to countenance its participation as a full-fledged in this court. And that echoes, we suggest, some of the submissions that we've made. Paragraph 43, the last few lines, two judges in a case called Packard accepted that a tribunal had standing to explain the record and advance its view of the appropriate standard of review and to argue that its decision was reasonable. It said at the following paragraph that that finding was supported by the need to make sure the decision on review of the tribunal's decision was fully informed, the tribunal being the party best to the court's attention to those considerations rooted in the specialised jurisdiction or expertise of the tribunal, which may render reasonable what otherwise would appear unreasonable to someone not versed in the intricacies of the specialised area. But Justice LaForest found that the tribunal could not go so far as to argue that its decision was correct. So there is plainly some reticence in Canada about a tribunal participating at all to expand its reasons, broadly for the reasons that we've identified. And just to conclude, the bottom of page 1980, paragraph 48, the court held that those cases should be read as the source of fundamental considerations that should guide the court's exercise of discretion in the context of the case. The two most important considerations drawn from those cases were the importance of having a fully informed adjudication of the issues before the court and the importance of maintaining tribunal impartiality. So we say the same principles taken into account in that context. And one other international judgment from the Supreme Court of Ireland that we asked the court to look at. It's tab 73, page 1945. Miley and Employment Appeals Tribunal. My lord, my lady, we can see from, in fact, I don't need to ask the court to look at the page number, but the EAT is a statutory tribunal in Ireland. Not the same as the EAT in this jurisdiction, but it's nevertheless a statutory tribunal of the same kind. That's paragraph 32, but I don't ask the court to look at it. Can I ask the court rather to look at the section on the law which starts on 1948, paragraph 23? It's well settled law that members of the judiciary have immunity from orders as to costs. However, that immunity is not absolute. Paragraph 24, we can see that the authorities considered are Irish authorities. So there's no overlap with domestic the England and Wales or Scottish authorities. The short passage that we asked the court to look at comes from paragraph 29 on page 1949, refers to a case called Casey, the question about costs against a body called the Private Security Appeals Board and the Private Security Authority. And there was opposition to a costs application, and a party who hadn't participated, this is 4 lines down, the respondent opposed the costs application and argued that no costs order should be made against it as it had not taken part in the proceedings. And then at the bottom of the paragraph, reference was made to a case called Cullen and EAT. And the quote there, we draw to the court's attention, when a statutory body like the EAT makes a decision which is challenged and then decides not to participate in the proceedings, the EAT must act judicially. They're a quasi-judicial body, did not take a partisan position in relation to the matter, and that is appropriate. They decided to leave it to the contesting parties to contest the issue. The approach adopted by lower courts and statutory quasi-judicial bodies when the decisions are challenged, and that is an appropriate approach. That's what happened here. It's submitted that in the absence of bad faith that no order should be made against the respondent, and I accept that is a general legal policy adopted by the courts in relation to these matters. I follow the approach. Accordingly, I make no order for costs. So the same approach taken in Ireland, and concluded that that is an appropriate approach. The reason being, the body should not take a partisan position in relation to the matter. So, my lord, my lady, of course, we don't say these cases are determinative of anything before this court, but we do say they assist in establishing the broad consensus that the principles that we say should be applied are appropriate. So I go on then to ask the question whether recent changes to the position of public funding should change the analysis. And the starting point must be that they could only do so if the appellant could show that the consequences of the approach in Davis, in light of such changes as there have been to the legal aid regime, were such as to give rise to so serious an impediment to access to justice as to outweigh the importance of the principles that we have already identified. And we respectfully submit that the appellant can't come close to doing so. The first thing to say is that there can be no doubt that Lord Justice Brooke had the importance of access to justice well in mind when Davis was decided. The Court of Appeal noted that in Fakiri, I can ask the court to go back to Fakiri, It's Authorities Bundle, tab 2, page 330. Can we start, please, at 339? Paragraph 31. Does my lord have page 339 in the main bundle? I'm grateful. Paragraph 31. I do not accept that Unison has marked a change in the jurisprudential landscape which enables us to depart from those authorities, that is Davis and Gourlay, even if we wish to do so. It's true that Unison focused upon the constitutional right of access to justice, but as Lord Justice Davis pointed out in the course of debate, the importance of access to justice was well recognised by July 1999, when the final report of Lord Wolfe on the civil justice system was published, and certainly by 2004. It's inconceivable that Lord Justice Brooke did not have it well in mind when he gave judgment in Davis, or Lord Justice Longmore when he gave judgment in Gourlay. And then on the following page at paragraph 35, in any event, I'm unpersuaded that the inability to obtain a costs order against a tribunal is any hindrance or impediment to access to justice. It did not deter the claimant, and generally, as I've described, those who appeal against immigration decisions of the Secretary of State are usually unable to recover costs over and above some fees from anyone. There's no suggestion before us that that regime deters prospective challenges. And he goes on to look at a CART claim, which is somewhat different. The reference to Unison, I should briefly mention, and of course, I can't avoid noting that, like the immigration tribunals referred to by Lord Justice Higginbotham at paragraph 35 of Fakiri, the Employment Tribunal, which is the forum which was in issue in Unison, is a no-costs jurisdiction. And nobody suggests that the unavailability of cost shifting in employment tribunals represents an unlawful impediment to access to justice. It is frequently argued, indeed, that having to resort to judicial review with a costs regime is less helpful than being able to bring proceedings in an employment tribunal, which is a no-costs jurisdiction. That is frequently argued in cases where claimants want access to the employment tribunal system. Not least, it was argued in this court last year in Gillam. The reality, we say, is that there is no such impediment in this context. Firstly, because of the role of the Secretary of State for Justice as a defendant or an interested party, as I addressed you on yesterday. Secondly, because even where there is no order for costs, the claimant's costs are likely to be covered by legal aid, which provides the benefit of costs protection if the claim is lost. And the court has in the bundle, I don't ask you to look it up now, but the Howard League case, which is page 1387, which confirms legal aid is available for both pre and post tariff hearings. So that is for pre-tariff hearings will necessarily be only about transfer rather than release. Page reference is 1398 for that. If the board acts improperly or unreasonably, costs may be awarded against it. Equally, if it properly and reasonably acts so as to defend its decision, as for example in DSD, costs can in those circumstances be awarded. And in any case, costs remain in the discretion of the court, and costs can be awarded against the board if its conduct or some other particular circumstance justifies such an order. The reality, we submit, is that the board has seen, and we suggest the court has been offered, no evidence of any legally aided prisoner being unable to challenge a decision of the board due to any of the concerns raised by the appellant. The board's litigation strategy, as the court has seen, was first published in 2013. The Court of Appeal's judgment in this case was handed down in 2017. We're now some 3 years later. There is no evidence that the current approach to costs causes any impediment to access to justice. And the submissions that we make about the significance to be attached to questions of funding in this context are all made without prejudice to that starting point. Perhaps the starting point or the high point of the appellant's case, so far as this aspect of the appeal is concerned, relies on the obiter dictum of Lord Hope at paragraph 25 of JFS, and the court looked at that yesterday. Page 838. In that section on no costs orders, one can see it starts at paragraph 24 at D on 838. It's important not to lose sight of what was being considered in JFS. It was an application for a protective costs order in circumstances where the Legal Services Commission had declined to continue to fund the claimant who had been successful in the Court of Appeal unless there was a PCO, essentially because the Commission concluded that the costs incurred would exceed the likely benefits. And the conclusion of the Supreme Court was that the Commission's decision was so unreasonable as to be unlawful. What we see at paragraph 24 needs to be viewed in that context. I don't propose to read it out. The court was taken to it yesterday and is no doubt familiar with it. The present case doesn't concern an application for a protective costs order. The proper context for this obiter dictum is important in understanding what it means. And what I won't try to do is to improve what the court below said about that. That's in the bundle at page 166. It's in the judgment of Lord Justice Hickinbottom in this case. Can I ask the court to look at paragraph 60? In fact, can I ask the court to read that to yourselves, please? And the court's conclusion at paragraph 61 is that the observations of Lord Hope in JFS have no relevance to a backward-looking order for costs in a case such as this. In determining the issue of costs against a court or tribunal, whether the claimant is publicly funded is irrelevant. For the reasons given in Davis and subsequently consistently reiterated by the courts, including by Lord Hope in JFS, in considering costs orders in public law claims, the court is to ignore the fact that the party seeking a costs order is publicly funded. That is equally applicable when the court is considering making no order for costs as against the defendant, court or tribunal. That fact has no relevance to or impact on the question of whether or not there should be no order for costs. In his submissions in reply, Mr. Southey appeared to accept that, was anxious that a publicly funded claimant should not be placed in a worse position. My lords, there are some more relevant observations on the issue in ZN Afghanistan. I'll come to that case in a moment. I notice it's 11:45. I don't know if this is an appropriate moment for a
Yes.
short break.
Yes, I think it probably is. Thank you very much, Mr. Collins. Before we adjourn, can I just draw to both councils' attention some authorities that you might want to consider when you are preparing your written submissions. The first, they're all House of Lords. The first is the case of Girvan and Inverness Farmers Dairy, 1998 session cases, House of Lords 1 at page 21, where there's a general dictum by Lord Hope to the effect that matters of practice and procedure should be left by the House of Lords to the inner house, and he refers to the statutory regime governing practice and procedure, the existence of a Rules Council and its scope for consultation. Then that's applied to Northern Ireland in the case of Boyle and SCA Packaging, 2009 UKHL 37, paragraph 16. And then of the greatest relevance, the case of Callery, CALLERY, and Gray, 2002 UK House of Lords 28, paragraphs 8, Lord Bingham, 17, Lord Hoffman, and 56, Lord Hope. It's a case about costs and the application of CPR 44 in relation to the uplift for success in conditional fee agreements and also premiums for after the event insurance, where, as Lord Bingham says, that responsibility for monitoring and controlling developing practice in a field such as this lies with the Court of Appeal and not the House of Lords. So you'll need to address that case in particular. Lord Leggett.
So, can I add another case to the list?
Yes, of course.
For a similar point. BPP Holdings against Revenue and Customs, 2017 One Weekly Law Reports 2945, paragraph 26.
Well, I think I was in that case myself, so I'm very grateful to be reminded of it.
Yes, you were.
Right. Well, thank you very much. Well, we'll adjourn now and resume in 5 minutes' time. Well, I think we're now ready to resume the hearing in Gourlay and the Parole Board. And Mr. Collins, I invite you to continue your submissions.
My Lord, thank you. Just before I do so, I've got some instructions about the organisation employing offender managers and so on. And it's this: what was the National Offender Management Service is now Her Majesty's Prison and Probation Service. Prison Service and Probation Service being subsets of HMPPS. The offender manager is from the Probation Service. The offender supervisor and the psychologist are from the Prison Service.
Thank you very much.
I was dealing with the authorities supporting the proposition that the fact that the party legally aided should not lead them to be treated more favourably in respect of costs than other parties. Part of the background to that is Section 30 of the Legal Aid Sentencing and Punishment of Offenders Act, LASPO, which is the provision, I'm going to ask the court to turn it up if you'll notice page 584, which provides that rights conferred on an individual for whom services are provided do not affect the principles on which the discretion of a court or tribunal is normally exercised. As I think my learned friend said yesterday, that's the successor provision of a series of statutory provisions which have gone before it. In the case of Musa, a divisional court considered the predecessor provision to section, or one of the predecessor provisions to section 30. And I can ask the court to look at tab 53, page 1. This was in a question about the portrait of legal claimants who had won on some issues, and my lord, can't hear you, my lord, I'm sorry.
There's an irony in this. The sound cut out when you gave the page reference, Mr. Collins. I'm sorry.
And then again, when you asked me for it. Yes, 1514, my lord.
1514?
Yes.
Thank you.
Paragraph 64. So this is in the context of a case where claimants won on some issues, defendants on others. And part of the submissions for the claimants was that the fact that they were legally aided should be taken into account. And at paragraph 64, the court said that to adopt the approach suggested by the claimant would be to disregard the mandatory wording of section 22(4). That's from the Access to Justice Act 1999. As I say, it's a predecessor provision to section 30. Noted that it wasn't considered by the Supreme Court in JFS. And then 5 lines from the bottom, despite the obvious regard we've had to the need to ensure that those of great skill conduct cases such as this, we cannot see how it would be equitable to depart in the circumstances from the ordinary rule for Parliament to consider these issues relating to litigation that is undertaken by highly skilled practitioners in these important areas of public interest. So the court concluded it couldn't disregard what it described as the mandatory wording of the section, but we don't say that that is determinative of the question, because the approach was qualified and the proper approach to the costs of a publicly funded claimant was considered by the Court of Appeal in ZN Afghanistan, which starts at 1813. But can I ask the court to go to 1837, please? 1837. This is within the judgment of my Lord, Lord Legate, sitting in the Court of Appeal, as he then did. And can I ask the court to look, please, on 1837 at paragraph 97, where his lordship expressed the view that in deciding what order to make about costs at the end of proceedings, the fact that a party is publicly funded can I do not consider that it can in principle be relevant, which accords with what was said in M and Croydon, and I'll come on to that. But his lordship confirmed that section 30 of LASPO does not establish an absolute rule that the fact must always be ignored, and we accept that. As Lord Justice Singh notes, section 30 says that the grant of legal aid shall not affect the principles on which the discretion of the court is normally exercised, thus leaving open the possibility it could be taken into account in abnormal or exceptional circumstances. The judgment goes on to say that it would be inconsistent with section 30 to build the fact that a party is publicly funded into the principles which govern the exercise of the court discretion under CPR 44.2, either generally or in a particular category of case. But in any event, irrespective of Section 30, treating the source of a party's funding as relevant would be unfair. As Lord Hope said in JFS, legally aided litigants should not be treated differently from those who are not. That applies equally whether the costs order proposed is less favourable or more favourable to the litigant than the order which would have been made if he or she had not been legally aided. A claimant who has been granted legal aid already has the advantages over other claimants, A, of public funding for the litigation, and B, that a costs order made against the claimant is ordinarily not enforceable. I can see no justification for adding to those advantages preferential treatment in deciding whether or what liability for costs should be imposed on the defendant. It would be unfair to a claimant who has had to fund the litigation herself if at the end of the proceedings the court were to decline to award her costs, which the defendant would have been ordered to pay if the claimant had been legally aided. By the same token, the fact that the solicitors acted for a legally aided claimant will otherwise go unpaid or will be paid at a lower rate is not a good reason to order the defendant to pay any costs to the claimant, which the defendant would not otherwise have been ordered to pay. As Lord Justice Brooke said in Davis, there is nothing in the cost rules to suggest that the financial welfare of a party's lawyers is a legitimate consideration when a court makes an order as to costs. And we respectfully endorse that part of the judgment. Now, His Lordship goes on to consider those dicta of Lord Hope in JFS.
And together with me, there are DPS ambassadors, which you might already know from the videos they posted already. So
I don't know if anybody else is getting the feedback that I'm getting. There's a voice from on.
Yes, I don't know. It's not coming from me, and all my colleagues are muted.
I think it's that may have been a technical error from our broadcast colleagues, with the mute button having now been put back on. I think it's come to an end. So I was going on to look at paragraph 99, which considers those dicta in JFS, and in particular paragraph 24. And the same point is made here as was made by Lord Justice Higginbottom in this case below, which is that the observation has to be seen in its proper context. In paragraph 49, about 6 or 8 lines down, the context was a cost capping order that each side should be liable for its own costs, whatever the outcome of the litigation. The effect of making such an order would have been to disapply the principles which normally govern the award of costs. So at the bottom of the paragraph, court concludes that Lord Hope's objection to the order is consistent with his endorsement of the principle that legally aided litigants should not be treated differently. And paragraph 100 confirms that His Lordship agreed with the approach of the Court of Appeal in Gourlay. Now, in ZN, Lord Justice Singh took a slightly different approach in that, as the court was shown yesterday, he concluded that the fact that a party was legally aided was not, to use his words, necessarily irrelevant. And he gave an example of how his approach might work at page 1835, just up a couple of pages, paragraph 91, down the bottom of that page. He says, if it's not necessarily irrelevant, how may it be relevant? He says it's important not to lay down any prescriptive rules, but he offers an example at paragraph 92. The example involves the Secretary of State conceding part of the claim, agreeing to a consent order, such that not all grounds have succeeded, but the claimant may feel he's obtained a victory in substance and obtained the outcome, which is often the most a person can realistically hope to obtain. And 4 lines to the bottom, when the court comes to consider the issue of costs, I stress again that everything depends on the particular facts, but the court may feel in such a case a claimant should be awarded his costs and not engage in too technical an exercise about precisely which ground succeeded. And it would be open in such a case for the court to take into account the considerations mentioned in JFS and also in CINO, which is one of the other cases the appellant relies on. And we'd suggest that's very far from the sorts of circumstances we're considering here. In fact, as the President of the Queen's Bench Division noted in his short judgment at the end of the report, it's not in practice very different from the way in which Lord Justice Leggett, as he then was, viewed it. And in fact, at paragraph 4 on 104, sorry, on page 1840, Lord Justice Leggett, as he then was, identified that he took the view that his approach was consistent with that recommended by Lord Justice Singh, albeit that the reasons were slightly different. We say the approach in ZN can't assist the appellant's case, but it's necessary to order costs and a claim for a judicial review of a court or tribunal, which remains neutral, in order to permit access to justice. It doesn't fit with the circumstances of the present case. And we say there's a series of other authorities which support the approach we ask the court to take. I'll try and deal with those very briefly before I deal at the end of my submissions with human rights cases. The first relevant case is M and Croydon, which has been referred to a number of times. Can I ask the court to look at 1472, please? Paragraph 44 at D on the page. 3 relevant general principles. The first is that any decision related to costs is primarily for the discretion of the trial judge. Second, at paragraph 45, a successful party can look to the unsuccessful party for his costs. And then the third, at paragraph 46, is that the basis upon which the successful party's lawyers are funded, whether privately in the traditional way, under a no-win, no-fee basis, by the community legal service, by a law centre or a pro bono arrangement, will rarely, if ever, make any difference to that party's right to recover costs. That point appears to me to be plainly right as a matter of principle, and it is supported by the second of the Boxall guidelines. Just to pause there, the second of the Boxall guidelines is that it is ordinarily irrelevant that a party is legally aided, and by what was said by this court in another, there's another couple of cases cited there. One of them is Barter, which provides that it's not an acceptable reason to make an order for costs on behalf of a claimant that publicly funded lawyers are or are claimed to be inadequately remunerated. Costs should be dealt with on their merits. My lord, that same approach was taken in RL and Croydon, 1612. Paragraph 78, this is Lord Justice Underhill. He concluded that the claimants were not entitled to their costs, and he expressed that he reached that conclusion with some reluctance because he was very conscious of the importance to solicitors undertaking publicly funded work of recovering costs on an inter partes basis, not only when they succeed in litigation, but when the litigation is resolved on the basis that represents success. He says, I'm all the more conscious of that factor in the present case where PLP's work on behalf of the claimants appears to have been of very high quality and showed exceptional commitment to their case, but that does not justify an award of costs for which I cannot find a principled basis. So the starting point is not whether the claimant is assisted by legally aided lawyers, even of the highest quality. The question is one of principle, as it was put in M and Croydon on the merits, and even in circumstances where the court was conscious of the difficulties faced by legal aid lawyers, that wasn't a reason to take a different view. And the court will see that Sir Rupert Jackson sat on this court and associated himself with the comments in the final paragraph, which appear to be, certainly given his agreement that the appeal should be dismissed, not only endorsing the quality of the work undertaken by the claimant's lawyers, but also confirming that that wasn't a reason to award costs in those circumstances. The last case that I take you to in relation to this legal aid point is Fakiri.
Can I, before you do, just ask you a point about the question you've just been addressing? Suppose one does treat legal aid not as a relevant consideration. The broader underlying argument is that if you're a prisoner who wants to challenge the parole board decision, unless you can get costs from someone, if you're successful in your challenge, then you can't do it, whether you're legally aided or on your own, or it'll be very difficult to do it.
Well, our answer is that the prisoner can do it, and it isn't very difficult to do it. And this case is an example of that being done, and all of the other judicial reviews which are taken against the parole board are further examples of that being done. And of course, the prisoner doesn't get his costs back before the board in the first place, nor does a claimant in the employment tribunal or many first-tier tribunals. So we say it's not in truth an impediment. The evidence is not here to say that absence of costs recovery prevents prisoners from obtaining access to justice, unless there is such an impediment to access to justice of the kind that was identified in Unison. Then there is nothing to outweigh the importance of the principles of independence and impartiality that we've already identified. My lords, my lady, the last case that I was going to touch on in relation to legal aid, Fakiri. Can we look, please, at 339? In fact, my apologies, I've already taken the court to paragraph 31, so I won't go over that again. Save to say that it's relevant in this context as well. The other relevant paragraph in Fakiri is on page 340, the following page, paragraph 38. This is in Lord Justice Hickinbottom's judgment in Fakiri. He deals at paragraph 38 with section 30 and with ZN. At G, he notes the example Lord Justice Singh gives where a claimant is successful in having a challenge decision of a public body quashed but is not successful on all of his grounds. He notes Lord Justice Legacy then was put the matter in a slightly different way, which was not dependent on whether the relevant individual is legally aided. Reference there to paragraph 104, which I've taken the court to, an approach which I favour, as apparently did the third member of the Constitution in ZN, Brian Levison, the President. In any event, in this case, in my firm view, there's nothing to affect the statutory principle, as we just go over the page. The fact that the appellant is publicly funded will not normally affect the exercise of the court's discretion, and in particular should not affect it adversely to him. So, my lords, we say, as a matter of principle and on the facts of the present case, there is nothing unlawful in applying the approach in Davis in the context of the claimants being in receipt of public funding. That leaves me with two matters to deal with. First of all, the ECHR cases referred to by the appellant. And there's a short issue of independence which was raised yesterday and which I'll deal with briefly at the end. But I start with the ECHR, and it arises in the same context which I've already been addressing the court on. In his case, the appellant placed somewhat tentative reliance on the convention, referring to the proposition that requiring a citizen to bear the costs of litigating to correct public law wrongs might, and I quote the appellant's case, potentially breach human rights. And we weren't sure to what extent the appellant pursued the argument that there was any such violation, but my learned friend touched on it yesterday, so I will deal with it briefly. The starting point is that the Convention does not require that a successful party in domestic proceedings must be reimbursed his costs, and that includes proceedings brought by an individual against the state. Authority for that proposition is tab 69, page 1842, case of Dello Prete and Italy. And it may be that it's sufficient for me just to take you to the head note right at the top. This is in relation to Article 6, the right of access to a court. The right of access to a court does not imply that the successful party in domestic proceedings will necessarily be reimbursed the costs of those proceedings unless there is evidence that these costs would constitute an impediment to access to a tribunal. So the case takes us no further forward than where we started. No requirements to have one's costs reimbursed, but access to justice is important for the purposes of the Convention in the same way as it is as a matter of domestic constitutional law. Now, we accept the proposition, which is derived from a case called Scordino, which the appellant refers to, that costs should not be so excessive as to constitute an unreasonable restriction on the right to lodge an application, but that's not what we're dealing with here, because a prisoner in the claimant's position who is entitled to legal aid bears no costs and the state pays whether he wins or loses. There's no question of an infringement of his right to access to a tribunal. And Scordino was addressed by the Court of Appeal in the Faulkner litigation, page 1256, paragraph 33. This is the judgment of Lady Justice Asplin. Scordino's case is concerned with fixed costs or taxes under a domestic system which may create an unreasonable restriction on the right to lodge an application seeking redress for the failings of the judicial system, and thus amount to an infringement of the right of access to the tribunal, and at its highest with legal costs which place an excessive burden on litigants where their application for relief from breach of a convention right is justified. It's a different context. It's closer perhaps to the unison context where fees act as a barrier to access to justice, but particularly in a context of a domestic system which itself created a difficulty.
There's in fact a discussion of this issue towards the end of the judgment in unison under reference to the Strasbourg authorities, making the point you've just made, that they're concerned with costs which act as a barrier in limine to being able to get your case up and running.
My lord, yes. Yesterday, the appellant identified a further case called Stankovic, which was a case in which the court first of all said, and we have this separately, it's not in the bundles. The court found on several occasions the court fee levied on the party to civil proceedings constituted a restriction that impaired the very essence of the applicant's right of access to a court. And that's a similar principle to the one I've just identified. But Stankovic doesn't purport to lay down any principle of general application about protection of a state body from an order for costs. It's simply a case where the court found the circumstances were manifestly unfair because it put the claimant at such a disadvantage that his rights of access to justice were impaired. None of the cases, the third one being Tarhan, which was a case where the court considered whether a requirement on a claimant to pay some of the state's legal costs in his own claim to recover property which the state had been appropriated amounted to a breach of A1P1. That doesn't give rise to an issue of fact or principle which assists with this case. None of those cases, we say, add to a very careful analysis of all of the relevant principles in the domestic legislation. They're all rather different. They are of less assistance than the authorities you've already looked at. And for those reasons, we invite the court to conclude the convention leads to no different conclusion than the domestic authorities I've already addressed you on. Finally, my lords and my lady, I ought to address an argument which was raised, we say, for the first time before this court, a suggestion that the board lacks independence, relying on Brooke and Voles, and for that reason cannot be treated as a court. I've left it till last, and I deal with it only briefly because it may be that the argument is something of a red herring, because as my Lord President identified yesterday, this case isn't about institutional independence in the way that Brooke and Voles were. It's about judicial decision-making independence. But this wasn't an issue before the Court of Appeal in any event, and it isn't right for it to find its way into the case now. I can ask the court to look at how it was dealt with by the Court of Appeal. Page 163, within the core bundle, paragraph 47. The study complained about various matters, and in particular an August 2014 direction. Leaving aside the Secretary of State's continuing role in determining transfer issues, there is no issue before this court as to the independence and impartiality of the board. And the appellant seeks to say, this is paragraph 47F of their case for your note, arguments based on Brooke were before the court because the appellant had raised them. And we note that is very carefully worded. It says arguments based on Brooke. It doesn't say an argument about independence of the board. And we note there's no mention of Voles at all, which was not relied on below. And it may be that that very careful wording is because the appellant can't say that the board's independence and impartiality were an issue before the Court of Appeal. And they weren't. And if one looks at the grounds of appeal on page 208, the grounds of appeal to the Court of Appeal, the grounds are listed at paragraph 2. And 2B, State provides in terms, the claimant contends the parole board is an independent executive non-departmental public body. There's nothing impugning the independence or impartiality of the board. If it had been a ground of appeal that the board lacked independence because the problems identified by the Court of Appeal in Brooke had never been addressed, but it would have been necessary for the court to hear evidence about that. And the court's plainly in no position now to address such an allegation, raised as it is almost in passing in a single sub-paragraph of the appellant's case, and in the absence of the evidence to deal with it. And it's simply wrong to suggest, as the appellant does at paragraph 46F, to suggest there's some sort of burden on the board to disprove an allegation of lack of independence which was not made below. But the allegation in any event is wrong because Brooke said that no further action was necessary in relation to directions. And the court has heard no suggestion in this case that there are directions which affect its independence. It was dealt with by the Court of Appeal for your note at paragraphs 14 and 48, and there's no appeal against that conclusion. But what Brooke confirms is not that the board, for our purposes, lacks independence, but on the contrary, that by its nature, it is a body required to demonstrate objective independence of the executive and of the parties, and to be seen to be both independent and impartial. Those are quotes from Brooke at paragraphs 5 and 20. The reality is that when judgments of the sort that Brooke is one are handed down by the courts, the board's practice is to seek to respond to them and to address any defects which are identified. Well, a finding of a problem doesn't mean that the board isn't independent and isn't a court. It's a finding that something needs to be sorted out, put the board back in the position it should have been. One last example, my lords, my lady, before I leave the topic. My Lord President mentioned yesterday the departure of the chair of the board, Professor Hardwick, and observed that a judge would not be told that his position was untenable. Point of detail that I should refer to, which is that Professor Hardwick wasn't in the position of a judge. He was the chair of the board, whereas it was the panel which had taken the decision that was in. But more importantly, for the purposes of the submission that I'm making, the issue of termination was considered following precisely the concern being raised that my Lord President identifies, and the issue of termination was considered and a new protocol put in place in between the board and the Secretary of State. It's an example of the board taking steps to ensure its independence is maintained when concerns are raised about some aspect of its practice or its arrangements which are inconsistent with it.
Just to make it clear, Mr. Collins, I wasn't expressing any concern. I was simply using it as an illustration of the difficulty of aligning entirely the parole board in the way it operated for at that time, at any rate, with a classic court.
My Lord, yes. I think my reference to concern was that the arrangements were modified because others raised concerns about the circumstances following on from Professor Hardwick's departure. But as I say, that concern being raised, or that issue, to put it neutrally, being raised, the board recognises that it must maintain a need for independence and impartiality, and it takes steps to ensure those are maintained. It's not simply a fact of saying, well, therefore, because a concern is raised, that means the board's not independent. It means that it has to do something to remain independent, or it may do, depending on the circumstances. And of course, we say that the need for independence and impartiality are hallmarks of a court, and the court had my submissions on that yesterday. My lords, my lady, unless further questions arise, those are my submissions.
Thank you very much, Mr. Collins. Mr. Saville.
My lord, thank you. Can I respond to my learned friend's submissions in the order broadly that he made them, so not adopting the structure I did in opening? Obviously, my learned friend started by making some factual points, and in particular made factual points about the nature of this challenge. And his first submission was that it was odd that the challenge was against the parole board, and wrong that it wasn't, that the Secretary of State for Justice wasn't an interested party. In response to that, my lord, the starting point in my submission has to be the judgment of Mr. Justice King. He didn't think there was anything wrong about the structure. That, we submit, reflected the fact the Secretary of State for Justice was not an active participant. True it is, employees of the Secretary of State were witnesses, but that's obviously a very different thing from participating and making a case. They were effectively just using their expertise to express an opinion. In terms of then the challenge and the nature of the challenge, my learned friend argued essentially that this was a challenge both to release and the recommendation. In our submission, although it's quite accept obviously the claim form and the grounds suggested that was the case, that was obviously not what was being sought, because once one looked at the parole board decision, which reflected, and we have the submissions if necessary that make this clear, which reflected what had been said before the parole board proceedings, it is clear that in the parole board proceedings, all that was being sought was a transfer to open conditions. So all that could be challenged in the judicial review was that. And the parole board, in our submission, would have been aware of that, and that's clearly reflected in the judgment of Mr. Justice King. More significantly, my learned friend argues it's that what we should have done essentially was wait for the Secretary of State for Justice to take a decision. In our submission, there are at least 3 good reasons why that it doesn't appear to be practice. And as I say, there's no case law suggesting that is it should be practice or is good practice. Firstly, from a prisoner's point of view, it results in delay. There is no obligation on the Secretary of State to take a decision within a particular period. Second, linked to that, there is a risk that time limits will be missed, and my learned friend can't, and I don't think did, suggest that one could be certain that time would be extended. But thirdly, if one wants a fair and lawful hearing before the parole board, which is what one does, considering recommendation, one's going to have to challenge the parole board because it's their decision that essentially needs to be quashed. And in our submission, Kumar, which my learned friend referred to, does not assist because it's concerned with a different thing. It's concerned with a departure from a recommendation. Obviously, if the Secretary of State departs from a recommendation, one would challenge the Secretary of State, but this is a different context. Turning then briefly to Davenport. Davenport is described as a practice note, but as far as I'm aware, that is just a practice of the law reporters. Doesn't say anything about what the judge thought of it. And ultimately, it was conceded that the Secretary of State for Justice should have been a party. There was no consideration, essentially, as to whether or not the Secretary of State for Justice is truly a party to a court for the purposes of the rule. But more important than that, whether or not the Secretary of State is a party doesn't determine whether or not the Secretary of State will be liable for costs. If one looks at the facts of this case, the Secretary of State played no role before the parole board. Secretary of State, we've got no reason to believe, would have played any greater role in the High Court. And in those circumstances, why would the Secretary of State be liable for costs? The Secretary of State had done nothing other than take a watching brief, essentially. Turning perhaps more fundamentally to the nature of the parole board, my learned friend pointed to authorities that demonstrated how the parole board must comply with Article 5.4 when liberty is an issue. But that doesn't mean that the court has features of a traditional court. The role in advising, for example, means it's closer to the executive. And the primary reason we referred, for example, to Osborne, to Vols, to Brooke, is essentially that to demonstrate that unlike, for example, the first-tier tribunal, which resulted in a sort of fairly fundamental change enacted in primary legislation, what's happened with the parole board is the parole board started off clearly as effectively part of the executive providing advice and has then gradually moved a bit away from that, but it still has features of that history, essentially, and they are the things that mean it is not like a classic court in our submission. Now, in that context, obviously, we are, as I've already indicated, dealing with a situation which, with what was being challenged, was the recommendation. Now, it's true, recommendations may be linked often will be probably in decision making with release decisions, but clearly they have to be given separate consideration. As my learned friend accepted, in many cases, a prisoner will be expected to go to open conditions before being released, which implies, obviously, from a prisoner's point of view, open conditions may be the realistic objective of any set of proceedings if they haven't been in open conditions. So as in this case, the prisoner may take the realistic step of saying, all I am challenging, or all I'm seeking rather, is a recommendation. And in relation to that, obviously the Secretary of State's role has to reflect the Hindawi concern that effectively the Secretary of State has to ultimately be the decision maker, and so has to avoid getting too closely involved. And that is ultimately, though, an important difference. The fact the Secretary of State will be the final decision maker in relation to a recommendation. In relation to a recommendation, it is clear that the parole board cannot comply with Article 5.4 because it doesn't make binding decisions. That is not unlawful, obviously, because Article 5.4 doesn't apply. It's also not unlawful as a matter of domestic law because it's a feature of the statutory scheme. But it does mean that in this context, the parole board is not performing as a court. It is performing much closer to the role of the executive. And my learned friend proposed a number of tests that might be applied when deciding whether Davis applied. And the first one he said was one needs to consider whether the parole board is required to be impartial. In my submission, that cannot be the test because many administrative bodies are required to be impartial. I accept, obviously, when making a recommendation, the parole board is required to be impartial, but it's not required in a court sense because it's not binding. Now, the second test my learned friend suggested was taken from DSD, and he suggested the issue was whether there was an exercise of judicial power on the part of the state. In my submission, when dealing with a recommendation, one isn't dealing with judicial power. It's about an administrative decision. It's advising. Obviously, release is about detention, but this is a function that we're looking at here that is retained by the executive. It's ultimately for the executive to decide where a prisoner is located. Many cases on prisoner location, not in relation to open conditions, generally will be decided by the executive. And so all the parole board is doing is providing advice. So it isn't exercising the judicial power of the state. And finally, in relation to this issue of what is the status of the parole board, my learned friend, correctly in my submission, accepted that when looking at what is a court, one needs to consider context. And that's, in my submission, important in this context, because obviously the context in this case is whether there is a good reason to depart from the normal rule that the loser pays or the winner receives costs in circumstances where, and I'll come back to this, there is reason to believe departing from that rule may have an impact on access to justice, will have an impact on access to justice. And that means in our submission, some of the other contexts may not be terribly relevant. Turning then to the litigation strategy, my learned friend argues, without any evidence, and he fairly accepts there's no evidence as to why the strategy was adopted, that the strategy was a recognition of the judicial function that the parole board is now performing. In our submission, it's very difficult to see how particularly the initial strategy is a recognition of that, not least because, of course, it continued to suggest that the parole board should regularly participate to defend certain of its judicial functions or decisions taken in the context of certain of its judicial functions. So as I indicated yesterday on opening, the strategy indicated that oral hearings decisions would be defended. Now, my learned friend argues the fact that there is a discretion to participate should be regarded as a positive aspect of the strategy. Well, the first thing I'd say about that, it's something I'll come back to, is if there is a discretion, it somewhat undermines my learned friend's sort of suggestion that as a matter of principle, the parole board should not participate in litigation in order to undermine its independence. But secondly, DSD, and I won't go back to it, Parole 87, indicates that without criticism, the board does on occasion seek to defend decisions on the facts. Paragraph 87 is where the parole board made submissions regarding rationality. And that does indicate that it will seek to defend its decisions. And that raises the question, if it will do so in some cases, why is the public interest any less in other cases where one is still talking about serious offenders and one is still talking about the same sort of considerations arising, namely the need to avoid people being unnecessarily held in custody, and at the same time the need to ensure that the public is protected. One other feature, obviously, of the strategy I highlighted was that the board recognises it can make concessions. And my learned friend explains that on the basis that it's in the interest of justice if an obvious error is identified early. I agree with that because it prevents a waste of resources. But then why not incentivize that if it's got wrong? I mean, on the facts of this case, the board accepted that it hadn't undertaken that error, that issue of assessing whether or not it should concede, and yet it suffered no penalty effectively from that. Whereas a normal litigant who exercises that decision making, who gets it wrong, obviously suffers a penalty for that, which is to incentivize them to concede cases that should be conceded early. Finally, my learned friend overnight produced the figures and said, perhaps unsurprisingly given his position, be cautious about drawing anything from trends. All I would say is that at the very least, though the drop, which is quite noticeable in cases in recent years, is consistent with the point we make, which is that there have been challenges to the right of access to justice in this context. Turning to the issue of Davis, my learned friend said the issue essentially was whether a court determining costs, could take account of the fact that the body whose decision was challenged was a court. In my submission, that's not the correct way of analysing this, and that's not how Mr. Justice King and the Court of Appeal understood the matter. They understood Davis as taking an approach that there was essentially a rule that there should be no order for costs unless a tribunal participated or in some way was guilty of flagrantly unacceptable conduct. And so the issue is there a rule, and should that rule apply? Now, my learned friend identifies, as he did in writing, 3 bases for that rule: independence, impartiality, and the fact that reasons should speak for themselves. A couple of points I'd make. Firstly, I'm not actually sure that there is any difference between independence and impartiality. Secondly, in terms of reasons, I'm not sure that's a justification for the position. It may mean that the court isn't prejudiced by not having it. It may mean that the court isn't prejudiced by not having an involvement. But 2 more fundamental points I'd make is that my learned friend didn't suggest those were matters identified in Davis. Now, I accept, of course, that doesn't mean the court can't take account of those matters. But what it does mean is that over the lengthy period of time where there's been consideration of whether or not court should participate, whether or not court should be subject to costs. It's not been suggested that the objection is a fundamental one about independence and impartiality. The concerns aren't expressed there. And indeed, obviously in Touche, in Davis, it was recognised that there may be advantages to courts appearing, and that wasn't suggested to be wrong as a matter of principle. And indeed, if those reasons were as powerful as my learned friend says, they would suggest courts should never be involved, but that clearly isn't the position.
But you may get a case where it's a good idea, for instance, that the coroner comes along to tell you what the procedure is, if that's a matter which is unclear without the assistance of the coroner. In other words, the court may be required to assist the court, not on the point of law at issue, but on other peripheral matters or tangential matters, which require a specialist source.
Well, the problem with that, which is the problem that Lord Justice Simon Brown made pointed to in Touche, is that if procedure is going to be relevant, that's presumably because the claimant has raised an issue about the procedure. At that stage, the claimant will be saying something about procedure, and whatever the coroner says is either going to support what the claimant says or is going to be contrary to what the claimant says. And so, however neutral the court seeks to be, and I'm not being critical of this, the court will in reality either be supporting or opposing the claimant, given that the coroner won't have conceded, presumably opposing the claimant. And that's not necessarily objectionable in my submission, as was recognised in Touche. Lord Justice Simon Brown regretted the fact that what he was going to do might discourage the attendance of coroners. But it does demonstrate in my submission the fact that there is nothing inherently objectionable about a coroner or a parole board or any other body coming along. And that's why I also point to DSD. Nobody suggested in DSD it was undesirable for the parole board to come along and say, this isn't an irrational decision. Can I then go back to just a couple of things that very briefly that my learned friend relied upon? Firstly, my learned friend pointed to a series of authorities, starting with Stoke and Gwent Magistrates Court. In my submission, one needs to be very careful about relying on those cases because they really do just set out the practice rather than why there are what the reasons are for that practice. Turning then to the Bangalore principles, the Bangalore principles do not prohibit, it's paragraph 72, it's core page, it's tab 80, page 2094 and para 72. They do not prohibit comments in the course of official duties. That is why in my submission, there was nothing effectively wrong in the parole board turning up in DSD. What it was doing was in the context of its official duties, it was saying, this is why the decision was a lawful one. Now, in judicial review proceedings, it said a judge shouldn't comment beyond the record. But in my submission, what that's referring to is the record of the judicial review. It's recognising that what would have been objectionable in DSD is for the parole board to come out to the media and say, essentially, this is why we got it wrong. And fundamentally, as a matter of domestic law in particular, there is nothing wrong with amplifying reasons. English, I think it's paragraph 15, I've lost the paragraph number, but I think it's paragraph 15, makes the point essentially that courts can be asked to amplify reasons because that's in the interest of everybody. It saves cost essentially. In terms of immunity, my learned friends sought to distinguish Mazar on the basis it was a claim under the Human Rights Act, and so the claim was essentially against I think it was the Lord Chancellor. But in my submission, the fundamental point it makes is consistent with common sense, which is there is a difference between personal liability and corporate liability. Corporate liability means that the judge has no personal interest in the outcome of the proceedings. Personal liability might mean that. And if in some sense there was a problem with judicial immunity, why is the court ever able to participate? Dealing with a number of other brief points, appeals, my learned friend says there's no difference. The difference between an appeal and a judicial review is that in an appeal, there is a clear list with another party, and the court doesn't have a power to concede. In this case, the court has the power to concede, it exercises that power, and if it doesn't exercise that power, it puts you as an individual to expense. The overseas authorities in our submission provide little assistance because all of them recognise that both of them rather recognise that there may be circumstances in which, well, in the Canadian case, it's recognised there may be circumstances in which a tribunal should appear. In the Miley case, the Irish case, it was recognised there may be cases where costs should be awarded. So ultimately, what they establish is that there is no objection in principle to the sorts of arguments that we're putting. Turning then to legal aid and access to justice. My learned friend put the question as whether we had established, by evidence essentially, that there were such serious consequences as to outweigh the general approach. In our submission, that's the wrong way of looking at it, firstly. It's, in our submission, important that the parole board essentially has to justify the departure from the normal rule in the CPR, based as that was on Wolf and all the research that went on. And the normal rule is obviously the winner receives their costs. Now, in terms of whether you need evidence, that wasn't the evidence in the approach in JFS rather, or ZN, and it wasn't the approach in our submission for good reason. And the good reason is, if you essentially wait until the evidence is gathered, the harm will be done. And it's obvious in our submission that if you cut legal aid, and in particular, if you incentivize essentially legal aid lawyers to succeed, you need to provide with costs if they do succeed. Now, my learned friend says nobody suggests that there's an impediment to justice in the fact that, for example, employment tribunals don't have a cost jurisdiction, or the parole board doesn't have a jurisdiction. But they are obviously different tribunals with their own legal aid regimes, or in the case of the employment tribunal, no legal aid regime. And here, the critical point, it goes back to the point, if one looks at the legal aid changes that have been made, those legal aid changes by, for example, imposing low rates if you don't succeed, are intended essentially to operate on the basis that lawyers who succeed are rewarded, and that lawyers who don't succeed struggle, basically. But that means you must be rewarded if you succeed. Now, how should that be taken into account? I want to be clear about this because there is a confusion in my submission about that. What Section 30 is concerned with is about individual cost awards. It is about the sort of point that was made in RL, which is the loser shouldn't suddenly get their costs because they're legally aided. What ZN and JFS demonstrate, my Lord Leggett in particular in ZN demonstrates, his judgment generates this, is that when looking at the cost regime generally, and whether or not, for example, the court should be particularly keen on making no order for costs, or should delve into the details of who actually won, it should take account of the economics of the market. And the economics of the market require, firstly, that legal aid lawyers recover their costs when they are successful, that CFA clients are able to recover their costs because otherwise there will be no CFA market. But that doesn't suggest they should be treated any better, because clearly private clients who succeed as a matter of justice should be able to recover their costs. And so it's not about saying on an individual case, a legal aid client should be treated differently or better, which is a lot of what the consideration is about. It's about the fact that in legal aid and in CFAs, but in private clients context as well, the market essentially depends on costs being recovered. And that's something that can properly be taken into account in our submission. And that's what the court did in ZN, where it was well aware of Section 30. My Lord, two final matters, the convention. Our point is that it will not always be, we accept rather, that it will not always be a violation of the convention if you don't receive your costs. But our point is there may be violations if Davis is applied rigidly. And probably the most important case, because it is a case about no costs, is Tarhan. And it is recent, and it postdates, as far as I can remember, Unison. And what that demonstrates is that it is objectionable, essentially, which is our starting point, for someone to have to incur costs to enforce their rights, because it was about the individual's own costs, because, as I say, it was effectively a no order for costs, and then not be able to recover them. And there can be circumstances as a result in our submission where there's a violation of the convention. And all of that points to Davis not being, the need for Davis not being regarded as a rigid rule in this context. Finally, in terms of independence, our point is about independence is that if one looks at the origins and the current operating arrangements of the parole board, it is not a classic court, and that is relevant when applying Davis. And before the Court of Appeal, and I give the court these references, it's core page 215, skeleton page 4.23. The appellant argued essentially that the parole board lacks the key features of an independent tribunal and was legally little different to other parole public authorities. And the Court of Appeal judgment, consistent with that, paragraph 45 Roman 1, recorded the first submission as being that effectively the parole board was not a court because it was closer to the executive. And that was noted essentially by the court in para 47, where it addressed that issue. And that in essence is, we would submit essentially what we're seeking to argue here. That, I think, covers everything that I need to cover. Can I just check that those who are metaphorically behind me have nothing that they think I should raise? I'm afraid that one of the problems we've discovered with the technology is that there's a time delay, so it takes a little time for them to catch up. Well, Lord, while I'm doing that, can I just mention, because two things actually, which so to save time. Firstly, we have agreed, my Lord, subject to the court's approval, a timetable to deal with the written submissions. That is the appellant rather to make submissions by the 27th of July. The response by 6th of August, I should say 27th of July, slightly over 10 days, but that's because 10 days isn't during a weekend, in fact. The response by the 6th of August, and then any necessary submissions in response to that, 11th of August.
Thank you.
My Lord, can I just say one other thing, which is that I'm sure Mr. Collins would join me in this. We're conscious, certainly I'm conscious, of the efforts that court staff have to put in to facilitate hearings of this nature, as do the judges, and we really appreciate, I think both parties, I'm sure, the efforts that are made to facilitate hearings at these times.
Well, it's very good of you to say so. Thank you.
My Lord, can I chime in on that? Just to say how incredibly helpful the staff have been, both in terms of the court staff and the broadcast staff in making all of this work. So it's much appreciated on this side as well.
Well, that's very kind of you. I'm sure they are listening behind the scenes.
And I've got confirmation, as I say, nobody else has anything more to say, I think.
Well, in that case, the court is grateful to you both for your submissions and to those who we haven't heard from, but who've no doubt been assisting you. We'll now take time to consider what we've heard so far, and we'll look forward to receiving your further submissions in due course, and we'll then let you have our own decision as soon as we can. Thank you very much. We'll adjourn now.